You're listening to Malgudi Podcast. As the outgoing Chief Justice of India, Ranjan Gogoi gets farewell at Supreme Court premises, our President, Mr. Ramnath Kovind, will administer the oath for the new CJI, Mr. Arvind Bobde, today. Justice Bobde will be the 47th Chief Justice of India. Today in the Upsc Radiolab, we shall see the powers of the Chief Justice of India and the evolution of collegium. The CJI is constitutionally supreme. The Supreme Court says he or she is the first among equals. The Chief Justice of India becomes an acting president when both the President and the Vice President's seat falls vacant. Chief Justice Muhammad Hidayatullah had become the acting President of India in one such instance in the year 1969. When the Supreme Court was established on January 26, 1950, the total number of judges in the Supreme Court was CJI plus 7 judges. But the Constitution gave powers to the Parliament to increase the number of judges in time as and when required. Therefore, the Parliament then enacted the Number of Judges Act 1956. Today, the strength of the Supreme Court judges is 31. Talking of the appointment of Chief Justice, from the period 1950, that is during the establishment of Supreme Court, to 1973, the practice had been to appoint the senior-most judge of the Supreme Court as the Chief Justice of India. In 1973, A.N. Ray was appointed as the Chief Justice of India, superseding 3 other seniors, namely Jaishankar Manilal Shalat, A.N. Grover, and K.S. Hegde. A similar situation was repeated in 1977 when M.U. Baig was appointed as a Chief Justice instead of H.R. Khanna. This discretion of the government was curtailed by the Supreme Court in the second judge's case. Now, talking of the second judge's case, it's famously called the 3 judges case, which took place in 3 different years. In 1981-82, in the S.P. Gupta case, the court held that consultation does not mean concurrence, that is, it is not binding and it only means a considerance, more like just an advice. In 1993, that is the second judge's case by J.S. Verma, Supreme Court said that the advice of it laid as a binding that it became mandatory for both appointment as well as transfers. In 1998, Shri K.R. Narayanan, the then President of India, consulted the Supreme Court for the appointment of the High Court judges under 3 articles, Article 124, Article 217 and Article 222 of the Constitution, where Article 124 talks about Supreme Court and the CJI. Article 217 talks about appointment and conditions of the office of a judge of a High Court. And Article 222, that is 222 of the Constitution, makes provision for the transfer of a judge from one High Court to another, where the initiation for the proposal of transfer had to be made by the CJI. Also in 1998, S.P. Baruch held that appointment of governor was above legislature. These 2 instances upheld the decision of the Supreme Court in 1993. From then, the word consultation never meant mere consideration. Coming to the qualifications of judge, a person to be appointed as a judge of the Supreme Court shall have the following qualifications. 1. He should be a citizen of India. 2. He should have been a judge of the High Court for 5 years. 3. He should have been an advocate of the High Court for 10 years. Or 4. He should be a distinguished jurist in the opinion of the President. There has been no minimum age prescribed for one to become CJI in the Constitution of India, but the Constitution of India mentions the retirement age for the Chief Justice of India. The CJI retires at the age of 65, so do other Supreme Court judges. The Supreme Court judges cannot practice after their retirement. So if I say tenure of judges, there is no minimum age, but there is an upper limit age of age 65. His seat falls vacant when he resigns. The resignation of the CJI is written to the President of India, and his seat falls vacant if he is removed from his office by the President on the recommendation of the Parliament. The removal of judges has been made a long and difficult process to maintain independence of judicial system and hence the judges. The President can issue a removal order. An address by Parliament has been made or has been presented to him in the same session for such removal. The address must have a special majority. That is a total membership of the House and a majority of not less than 2/3 of the members of that House present and voting. There are only two grounds for removal. One is proved misbehavior and two, incapacity. The Judges' Enquiry Act of 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment, although let us remember the word impeachment is never mentioned in our Constitution, be it for President or for the CJI. It is always removal. So what's the process under the Judges' Enquiry Act 1968? So at least 100 members of the Lok Sabha and 50 members of the Rajya Sabha have to sign a removal motion and submit it to the Speaker or the Chairman if it is of the Rajya Sabha. The Speaker or the Chairman then decides to admit or not admit the motion. If it is not admitted, obviously there is no point, but if the Chairman or the Speaker admits the motion, a 3-member committee is formed to investigate into the charges. The 3-member committee will consist of the Chief Justice of India or a judge of the Supreme Court, depending on who is blamed, 2, the Chief Justice of a High Court, and 3, a distinguished jurist. If the judge is found guilty by the committee for 2 reasons, either of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is passed by each House of the Parliament by a special majority, an address is presented to the President for removal of the judge. Finally, the President passes an order for removal of the judge. The wages, allowance, pension, leave, etc. are determined by the Parliament and borne by the state. The salary of the Chief Justice of India is taken from the Consolidated Fund of India. Let's take a look at the collegium. After the 1993 rule, where the 9-member bench upheld that judges' seniority must be considered for appointment as a CJI, a collegium was formed. Historically, the word collegium has a Russian origin. It is an advisory or administrative board in Russia. In India, we have used the same term for a group of senior Supreme Court judges. The collegium consists of basically 5 members, 1, the CJI, and 4 other senior-most Supreme Court judges. Consultation with the collegium is obligatory for the President for certain decisions like appointment of the High Court judges. There are certain powers for the collegium. The collegium can take decision on promoting High Court judges to Supreme Court. The collegium has certain guidelines, to be precise 9 guidelines for function of its own group. We all are aware of the 121st Amendment to the Constitution, the NJAC, the National Judicial Appointment Commission. When the collegium was constantly accused of nepotism and favoritism, in 2014 the government came up with its 121st Amendment to the Constitution, where the National Judicial Appointment Commission had a 6-member team, headed by the CJI as the chairperson, 2 senior Supreme Court judges, Union Minister of Law and Justice, 2 nominated members by the CJI, the Prime Minister, and the Leader of Opposition. Out of these 2 members, 1 of them will be from the scheduled caste, the scheduled tribes, or the OBC, or the minority, or be a woman. But in October 2015, the Supreme Court struck down NJAC, calling it unconstitutional, and restored the collegium system. So this is a complete capsule covering all about the CJI and their powers. Thanking you until we come up with the next episode. You're listening to Malgudi Podcast.